Okay. The amendments of Section 9 of the Principal Act (IBC 2016) introduced by the Insolvency and Bankruptcy Code Amendment Act 2016 for the purpose of clarification. This act is published in the official gazette, but the enforcement date is yet to notify. Are the aim at streamlining the application process for operational creditors and enforcing a stricter judicial timeline to prevent the admission bottleneck. Okay. The era of filing and waiting is over. Legacy system, reactionary litigation, like reliance on the adjudicating authority to wait evidence, acceptance of the systematic delay, and the admission bottleneck, which leads to ultimately admission bottleneck. There is a long waiting period to get petition admitted. But 2016 amendments front-loaded. It's a completely watertight, not exactly a watertight, but completely timeline-driven process is introduced by 2016 Amendment Act. Okay, pre-verified evidence, section 215, subsection 3, mandate that they have to maintain a record with information utilities before filing a section 9 application. And section 9(3) subsection E change substituted word prescribed with specified. Specified generally refers to that control has given to to IBBI. Okay, and strict judicial accountabilities. Now the 14 days time period is mandatory in nature, and if the adjudicating authority is failed to recognize, fail to pass an order within 14 days, they have to record a reason for not doing so. Okay, this is the complete overview of Section 9. What are the amendments are introduced? Let's deep dive into details of it. Okay, insert. Okay, section. The Act inserted new proviso in subsection 5 of Section 9 creates a formal accountability mechanism for adjudicating authority. The 14-day mandate, the adjudicating authority required to pass an order of admission or rejection within 14 days of receiving a Section 9 application. Recorded accountability if failed to do so, pass an order within the 14 days. It is now statutorily mandated to record a reason for such delay in writing. Impact this a systematic shift towards a judicial accountability by requiring the written records of delay. The amendment seeks to reduce the admission bottleneck that previously allowed the applicants to remain in a limbo for extended period without any consequences. Okay, the agility dial, shifting evidentiary control. Earlier, central government has the control because under section 9(3), section 9 subsection 3E uses the word prescribed. Now it is substituted by specified. When the word prescribed generally refers to rules made by the central government, whereas specified refers to regulation made by the IBBI. This allows the regulator to more dynamic adaptation the information required for the Section 9 application to reflect the changing market practices and to address the emerging procedural hurdles. Okay, what happens by this substitution? There is a regulatory shift because central government make a rule. It will take time. They are static and not too easily amendable. But when it's come from IBBI, it's a regulator and currently working close connection with all the information utilities, IP, and every actor actually. That's why they are very easy to adapt the market practice. Okay, this is a major shift. Next is that these changes must be read alongside the new amendment in section 215 subsection 3, which mandates that the operational creditor are now required to authenticate the financial information with an information utility before filing Section 9 application, so that we have a pre-verified evidence of debt. Adjudicating authority that has less discretion to go into that there is a pre-existing there is a debt or not, because for this is what operational creditor are face delayed because of there is a long hearings regarding only to decide whether the debt is exist or not. Now if you have a financial record, it strengthens the 14 days timeline. Okay. Uh, Now the accountability timer is that for Section 7 and Section 9, Section 10 ensure that adjudicating authority held the same standard of efficiency and accountability regardless of who initiating the insolvency process. Okay, this is okay. This is what I did. Okay. And in a conclusion, we can say that law replaces the word prescribed with specified in Section 93E. The board now control additional information requirement, faster regulatory updates without legislative delays, more responsive compliance framework. The authority has to pass order of admission or rejecting the application within 14 days. If they are failing to do so, they have to record a reason in writing. An operational creditor must now authenticate the financial information with information utility. Debt is pre-verified before reaching the tribunal, reduces a dispute at the admission stage, and strengthens the 14 days disposal timeline. Okay. So earlier, there are only three pain points now: admission delay, rigid document rules, and weak evidentiary verification. But 2026 amendment fixes all three systematically. Thank you.